Welcome to the National Electrical and Communications Association and the Fair Work Ombudsman's electronic seminar for the Electrical, Electronic and Communications Contracting Industry Award 2010. My name is Oliver Judd. I'm the Employee Relations Manager for NECA, and I will also be your Fair Work Liaison Officer. If you have any questions in relation to this video, feel free to contact me on the details that will be provided later on to discuss any of the issues you may have. Please note that this video is supplemented by a guide to the modern award and the National Employment Standards. We recommend that you have a copy available with you during the video to assist you to understand the scenarios that are dealt with. To obtain a copy, simply fill your details into the form on this page and NECA will get a copy to you. This presentation is broken into chapters, each containing an explanation of each of the National Employment Standards, or NES, and an explanation of the more critical provisions of the Electrical, Electronic and Communications Contracting Award 2010. It is important that you understand the obligations outlined in this video, as there are significant fines that can be imposed where businesses do not comply. A set of 10 standards, known as the National Employment Standards, or NES, was introduced on 1 January 2010 as part of the implementation of the Fair Work Act 2009. These standards apply to every employee in Australia, except non-constitutional employees engaged in Western Australia. This generally means employees of sole traders, partnerships, and government and public institutions, regardless of their type of employment. This chapter deals with notice of termination. Employers do have the legal right to terminate the employment of their employees. However, this right must be exercised consistently with the terms of the employee's contract of employment and the Fair Work Act. Employers must also exercise this right fairly. If a company fails in this regard, an employee may successfully challenge the fairness of their termination with Fair Work Australia and receive compensation. Where an employer has made the decision to terminate an employee, the employer must give such an employee a minimum period of notice as outlined on page 53 of the guide. Where an employee is over 45 years of age at the time of termination and has a period of continuous service with the employer in excess of 2 years, that employee shall be entitled to 1 week's notice in addition to those notice periods identified at page 53 of the guide. The modern award states that the notice period required to be given by an employee upon resignation is the same as that required of an employer, except that there is no requirement on the employee to give additional notice based on the age of the employee concerned. If an employee fails to give the requisite notice, the employer shall have the right to withhold wages and/or entitlements due to the employee on termination, with a maximum amount withheld equal to the equivalent pay for the period of notice. An employer will not have to provide notice of termination in the following circumstances. 1. An employee is employed for a specified period of time, for a specified task, or for a duration of a specified season. 2. An employee whose employment is terminated because of serious misconduct. Serious misconduct is defined at Regulation 1.07 of the Fair Work Regulations, and it includes such things as theft, fraud, violence in the workplace, and serious breaches of occupational health and safety laws which result in imminent risk of harm to themselves and other employees. 3. A casual employee that is not engaged on a regular and systematic basis. And 4. An employee, other than an apprentice, to whom a training arrangement applies and whose employment is for a specified period of time or is, for any reason, limited to the duration of the training agreement. Rather than asking a terminated employee to work through their notice period, an employer can decide to provide payment in lieu of the notice to the terminated employee. Employees may be terminated by part of the period of notice specified and part payment in lieu thereof. An employee receiving payment in lieu of notice will be entitled to be paid what that employee would have normally been paid had they worked through the period of notice. This may include such things as allowances and overtime. Notice of termination must be in writing and may be effected in any one of the following ways. 1. Delivering it to the employee personally. Or 2. Leaving it at the employee's last known address. Or 3. Sending it by prepaid post to the employee's last known address. Thank you for watching this video. We encourage you to watch all the chapters in this series. If you have any questions, you can contact me on the details that are shown, and if you haven't already obtained a copy of the guide, we strongly recommend that you get one as soon as possible.